Now, what was I one? Oh, okay, I was talking about 135. And we'll go to 11:45 with this one. Give us 10 minutes. This is the one this is the bill that came up the other day, and I just want to throw a question on the floor for you who know the right to know law and have more experience with it than I do. Yes.
Just for your information, I believe for about 10 minutes before 12.
Okay.
So if there's any other votes that need to be taken.
But we won't. I don't think we'll be voting on it. Okay. So my question was, and it's in here in the remedies, that instead of may, the court shall invalidate. The court shall invalidate any action of a public body or agency taken at a meeting held in violation of the provisions of this chapter. Right now it says,
and then it strikes out the language
if the circumstances justify such invalidation. So my simple comment, just to get the conversation going, is what is wrong with that? If it's an illegal meeting, shame, shame. If it's an illegal meeting, nothing that's done in that meeting should be valid to begin with. Tell me why I'm wrong.
And the concerns that were expressed at the hearing were that if a meeting is taken improvidently, and if, for example, a nursing home bond is floated, by the time the court case arising out of that has wended its way where it's going to wend, the nursing home, the bond may be out there, the nursing home may be half built, and there was a significant amount of concern expressed at the committee that this, because it removes all discretion from the judge. The concern of the proponents of the bill stated most of the time they don't invalidate because the consequences of invalidation are too onerous. If you mandate invalidation, the onerous consequences, which may cost hundreds of thousands or millions of dollars to taxpayers, the judge has no discretion. Those costs, if costs there are going to be passed on to the taxpayer. And so there was a significant amount of discussion back and forth between committee members and those who testified about the possibility of some middle ground of tightening up the standards here while also making it clear to judges that the presumption was more towards invalidation, but retaining some discretion so that the consequences basically to the taxpayers were not draconian.
Okay.
A couple of comments. One is that we have also in the legislation the remedies provision, which would allow for civil penalties against individuals who violate the right to know law. And I think it would be prudent to let that become law and go into effect before we took this next step, which is a bit draconian. I also think that as a practical matter, a judge who's looking at a right to know violation and knows that if he or she determines that there's a violation, all of these millions of dollars are going to be charged to taxpayers, is going to tend towards deciding there is not a right to know violation. And so it'll actually have the opposite effect of what they're looking for. And you can envision, if you get, on the other hand, a judge who is a stickler for the law, because we recently passed it, there is a provision now where if it's an emergency, you can have a meeting without a quorum, and you can have somebody participate by telephone in that meeting. One of the requirements in the law is that the person tell you who else is in the room with them. Well, what if they forget to do that? I mean, that technically you violated the law, and and again, to use the, there's a flood going on and you've decided to spend money to do this or that or the other thing, I mean, it just seems to me that it's, you have to have a little more faith in the judges if it's true that they have not invalidated any actions, and I'm not aware that they have. They also haven't had this other tool of the civil penalty to use before. So I think it's just premature to do this.
Okay.
Yeah, just to follow up on what Steve was saying, that example, I actually testified before the Judiciary Committee for information regarding this bill toward the end. They go on for quite a while. But my point for information was that in the circumstance, say, where you do have someone appearing electronically and they are required to inform the body and the public who's in the room with them, if they don't, it's a violation that under this proposed legislation would require undoing anything that board meeting had done, emergency or otherwise. Also, the point that I make is that this could be ripe for some type of mischief or foolery based upon a perhaps disgruntled member of the board. If it's a 12-member board, you have one person appearing electronically, they could perhaps, God forbid, purposely not inform who's in the room, have a